What is it we can accomplish today to make this case go smoother? Why are we here?
Well, I believe one thing, if the court wants us to, we can take a little 10-minute break, work out this jury question here.
We can resolve the questionnaires and the PowerPoint. Can we do that today?
Sure. I don't see any reason why not.
What else? I did notice that during the prior proceeding, the Newsom case, that Judge Kennedy would not let the parties voir dire on venue, and both sides seem to accept that. Mr. Haas, you may have a different opinion of that because you're new to this case, but do y'all recall that coming up?
I do, Your Honor. Our objection was to the defense categorizing venue as an element of the offense. Not that they couldn't voir dire on the fact that venue does need to be shown, but venue is proven by a preponderance of the evidence, not by beyond a reasonable doubt, which is the implication that we thought their PowerPoint was making, because they included it with all the other elements that have to be proven beyond reasonable doubt. I don't think anybody disagreed with that position. It was just a
Venue does not have to be proved beyond a reasonable doubt. Everybody agrees on that.
Yes, sir.
Yes, sir.
But it's not even in the jury charge. It doesn't. I've never seen a jury charge that says venue is proven by preponderance of the evidence.
No, and I think that there's I didn't know we were going to discuss this, but there's a pretty recent Court of Criminal Appeals case that discusses that issue of venue and print, and basically it's a non-issue.
So if the judge says don't voir dire on it, that it's not error. I mean, is that what it says, or?
It basically, no, what that case says is that there was an appeal filed basically stating that venue wasn't proven or it was unclear where venue was, and the Court of Criminal Appeals says that doesn't make any difference. Venue's not going to be an issue in this case.
Well, the only thing is sometimes you get hung up on voir dire with an individual juror. If you spend a lot of time, the state proves everything else beyond reasonable doubt, no evidence of venue. Can you find the person not guilty? And I was trying to avoid all that if the court has the authority to do that.
Let me see if I can find this case real quick, Judge.
I mean, Judge Kennedy said that that's what she did and didn't get much objection from either side. Now, I know, Mr. Haas, you were not in that case.
In this case, the state's posture on that question is slightly different because it's not a change of venue case. There's not, I think, going to be any question that these deceased individuals were found in this county. The arrest was made in this county. Everything that happened in this county, so it's not going to be as much of an issue for those jurors, I think.
Well, if we could avoid having to go into that lengthy discussion on venue on each potential juror.
Yeah, and our only objection would be, Judge, that we do think that it would be inappropriate to suggest to a juror that they must acquit if they find every element of the offense that the person committed true, but they haven't found venue beyond reasonable doubt. I mean, if venue is an issue, then I think they do get an instruction that it would be by preponderance of the evidence. I don't think there's a good faith basis to bring that up in this case, but I do think that's the law.
While you're looking for that case, let me just make some other comments. We're going to be better equipped on our big jury selection day than Judge Kennedy was trying to do too much that day. If you'll recall, she had trying to give Judge Charles a jury panel and qualify a panel for the Newsom case. I think we've long ago put on the record that this is just going to be a, quote, regular jury panel, Mr. Haas. It's not going to be a, quote, special capital jury panel come in. I think that's been established. Is that correct, Mr. Haas?
Yes, sir.
Okay. And I've had the opportunity to go back and read the court transcript and kind of get my mind around how we're going to proceed. That's why I want to talk to you about this. as I understand it, we would, the 188th District Court is considered the central jury panel room for Gregg County. So all the jurors show up there, and this is going to be, we've got the date, it's Tuesday, March the 17th. We're going to have that all to ourselves that day. And, the court would go through the standard qualifications and exemptions and hardships. The defendant would not be in the courtroom while that went on. Mr. Haas?
Yes, sir, I'm listening.
Okay. Lawyers are welcome to be there. I think Mr. Hagan was there. I don't know if you were, but Mr. Hagan was there. I don't know if the state was there when Ms. Kennedy, Judge Kennedy went through that. So she did the standard qualifications, exemptions, and hardships and got all that done. And then, best I can tell from reading the record, she put the panel outside of the hall, and we got the defendant in the courtroom somehow. I guess, I don't know if he was in the side room or not.
Yeah, he was in the side room for quite a while with us.
Okay.
You know that.
And we get the defendant in so the jury panel doesn't know that he's in custody, and bring the jury panel in and seat them, see if we're going to have a reshuffle, and then I'll begin the court voir dire and go from there. Is that how we did it? Yeah. Both sides okay with that? The question is, I don't think a defendant has a right to be present during the general jury panel qualifications, what I'm trying to say.
I think they do, Your Honor. I think he has the right to be there. I think there are a lot of counties where that doesn't happen and nobody objects to it because they do like a general pool on a
Well,
different day or
and
something.
then I'm going to ask, do y'all want him there for that, Mr. Ross? Okay. Okay. So, for the whole 9 yards, you want him in the courtroom, okay?
Yes, sir.
All right.
And let me ask the court how the court intends to proceed. I would imagine on that particular day, I don't even know how many people the district clerk's office is summoning.
District clerk's up here.
Okay, sorry, court coordinator. 300, 400, 500,
We're probably more towards 1,000.
1,000? And how many would you expect historically to show up?
We'll probably have between 300 and 400.
Okay, that's what I figured. So the people that'll show up, and I don't anticipate, of course, I hadn't thought about this right now until now. I don't anticipate we're going to be filing any writs of attachment for any jurors. So, who comes in, that's who we're left with. So they're going to come in, and then the way they do it in Smith County, then the judge goes down, takes exemptions, excuses, reasons, particularly, are you over the age of 75, I think it is now, maybe 80, children left alone, things of that sort, convicted of a felony. Then after that process is concluded, and the people who are statutorily precluded from sitting on a jury, or if they so desire, they want to be excused, those people leave. Then we are going to go someplace. The court's going to do its general voir dire, give the questionnaires to the juries, have them jurors, and then have them complete them, provide them to the clerk's office. They'll be provided to us, and I think that's all going to happen on the 18th.
The 17th.
17th. And then the jurors will be called back individually, starting on the 30th. Is that basically how it's going to work?
Well, and that's what I was trying to ask you about. In Smith County, I don't think they bring the defendants down to your big jury panel room.
They do on Calvary.
They do? Okay, I stand corrected. So when you have a capital murder case with the state seeking the death penalty in Smith County, the defendant will be down there for the whole proceeding?
Yes, sir.
Okay.
Of course, it's been a while since I've been involved in a death penalty case.
Well,
But the ones I have been involved in the past,